各位同事早晨啊，恭喜發財啊！過咗年之後第一次開會，咁啊喺度祝大家咧身體健康，萬事勝意。我哋夠法定人數，咁我哋就請官員入嚟先啦，好嘛？各位官員早晨啊。
Good morning, representatives from the administration. May I welcome Mr. David Wong, Deputy Secretary, and his team for attending today's meeting. Well, at the last meeting on the 3rd of February, we completed the scrutiny of Clause 26, which is to amend Section 44. So if there are no questions from members, we can start today with Clause 27, that is C3007 of the Blue Bill. So, over to you, Deputy Secretary, or Ms. Zhong. Good morning, Happy New Year. Well, we stopped at Section 44 last time, and this the clause we are starting today is Section 45 about educational establishments. So in relation to reprographic copying made by educational establishments, we allow such works to be published. Now in the heading, we're going to amend the heading by repealing reprographic copying made by educational establishments or pupils of passages from published works and substitute it by copying or communication by educational establishments or pupils, passages or extracts from published works. This is subsection 1. That is the educational establishment or pupils or passages can communicate and to an authorized recipient of a copy of an artistic work, a passage from a published literary, dramatic, or musical work, or an extract from a published sound recording or film. And that means that we have amended the paragraph by adding published sound recording or film. That is, the scope has been widened. As for subsection 2, the original subsection 2 will be deleted. So 1A is added. A person authorized by an educational establishment may, without infringing copyright, communicate to an authorized recipient a copy of an artistic work, a passage from a published literary, dramatic, or musical work, or an extract from a published sound recording or film that has been made in accordance with subsection 1 if the following conditions are met. And the conditions are: A, the person makes the communication for the educational purposes of the establishment, and B, the establishment takes all reasonable steps to ensure that 1, only authorized recipients receive the communication, and 2, the authorized recipients do not make any copy or further transmission of the communication. Now, this is a new condition. After widening the scope for published works, we impose reasonable conditions in the sense that only qualified personnel can further transmit or communicate the works to other recipients. And for subsection 2, copying or communicating to authorized recipients is not authorized by this section if, or to the extent, that the licenses under licensing schemes are available authorizing the copying or communication in question, and the person making the copies or communication in question knew or ought to have been aware of that fact. So in fact, the existing subsection 2 has been deleted, but we have added the word communicating, and the new subsection 2 bears the same meaning as the previous subsection 2. In fact, we talked about section 44 and other sections such as 41A, and the conditions are actually the same or similar. If there are no questions, I'll move on to subsection 3, where a copy which would otherwise be an infringing copy is made in accordance with this section, but is subsequently dealt with. It is treated as an infringing copy for the purposes of that dealing, and if that dealing infringes copyright, for all subsequent purposes. So here we have an amendment. Last time we talked about the wording of dealt with, and this carries a similar meaning. Subsection 4, the last subsection. For the purposes of subsection 3, a copy is dealt with if it is A. possessed, exhibited in public, or distributed otherwise than for the educational purposes of the educational establishment concerned, for the purpose of and in the course of any trade or business. B. sold or let for hire, or offered or exposed for sale or hire. C. communicated to the public unless that communication is not an infringement of copyright by virtue of subsection 1A. Subsection 5. Authorized recipient in relation to a communication made by a person authorized by an educational establishment means a teacher or pupil of the establishment who has been authorized by or on behalf of the establishment to receive the communication. So that's all about the exemptions under section 45. Mr. Sin Chung Kai. Now let me first talk about authorized recipient. I think we should widen the scope because quite a lot of schools have teaching assistants. I don't know whether a teacher also covers those not directly engaged in teaching, but are engaged in relevant teaching matters. And as for pupil, I don't know whether it only includes full-time pupil or half-time pupils as well. I think the wording is problematic. I don't know whether it's because of the Chinese or English version. In English, it's authorized recipient. But no, there is, one doesn't need to apply for authorization. You can be an authorized recipient as long as you study there. So shouldn't it be approved recipient, something like that, instead of authorized? Because as an ordinary person, I don't know whether I haven't been given any authorization because I've never applied for one. Yes, Ms. Zhang. The original intent is that there is no need for official approval or authorization. The exemption is for educational establishments and pupils' benefit, so that when students take a certain course, or if teaching activities are involved, then under the exemption, communication or distribution may be allowed, and the relevant pupils and the educational establishment may be authorized to receive the communication. Now, Mr. Sin Chung Kai asked whether a teacher would cover teaching assistants. Actually, they're covered. That's our original intent, because an authorized recipient could mean the teacher, the teaching assistant, or pupil of the establishment. So this is for the convenience of the teacher, teaching assistant, or the pupil of the establishment, so that when they receive the communication, they can rely on this section. Well, just like to add something, because subsection 5, the interpretation. Now, the teacher of the establishment, and then it says in relation to a communication made by a person authorized by an educational establishment, and then you only refer to teacher. What about teaching assistants?
And working staff. How do you deal with those categories of persons, because they're not included in the definition? If you refer to the communication part, since the educational establishment is authorized to make the communication, and person who has been authorized by or on behalf of the establishment to receive the communication, then the authorized person, we do not specify the ranks of such a person, whether he be a teacher or a teaching assistant. So we're only saying that such works could be communicated through the intranet to the pupils, and that is allowed. The latter part is about the recipient of the, and we're referring to the teachers and the pupils of the establishment. And of course, a teaching assistant, if he needs to receive such communication, they would also be included. Ms. Sito. Thank you. Let me follow up on Mr. Sin Chung Kai's point. In the interpretation, why for teacher, why don't you simply replace it by teaching staff? And also, parents may it is possible that parents may also receive such communication, especially parents of pupils in kindergartens and primary schools. And secondly, under Part 4, subsection 4, if it is not for the purpose of the educational establishment concerned, and it's for the purpose of or in the course of any trade or business, then it's regarded as a trade or business. For many schools, when they recruit new students, they may organize open days, and the pupils have yet to be admitted. During the recruitment days, or when these establishments organize open days, they may play certain videotapes, and they may show certain homeworks which are done by the pupils and so on. Then they would not be exempted because they are engaged in some form of trade or business, although it's not for profit. In the Copyright Bill of 2000, I think we were told that the business, the activities of education institutions is regarded as a business. So when they try to have student recruitment, that is also, kind of business. So I can't imagine that the open day organized by the school is actually, a purpose of the institution. I think the purpose of the section is that if education establishments were to prepare certain extracts, and if, according to Ms. Sit Ho, if the school may broadcast or communicate certain extracts when they are organizing open days or recruiting new students. And I think such excerpts are only intended to inform others about homeworks done by the pupils and so on. If it is used for such a purpose, then the school would not need to copy a large parts of the original works. If you want to show people what sort of homework the pupils need to do or what materials are being used in the course of teaching, such purposes is different from the purpose under 45. So here we would want to limit it for the purpose of teaching, so that the establishment can quote a larger percentage. If it is only for the purpose of student recruitment, then the excerpts or extracts that they need to use may not be so large. It merely serves to inform people about the materials to be used. So in this case, you may not to invoke the exemption provided under this subsection to make sure that you will not be infringing the copyrights. So the extracts that you referred to just now could only constitute a small part of the original works. Nobody may do any editing. I think the school may only, use a computer and then display all the materials. And so I don't want us to simply take things for granted, and then once it is written in the law, it becomes a trap. So either you should say, either the education authorities inform all the schools and school sponsoring bodies that if they were to have open days or recruiting new students, they should not use any infringement works. I don't think the school can afford to have a legal advisor to scrutinize the details of the bill. I think we've been here scrutinizing the bill for almost 2 years. Ms. Ho, regarding teaching, the Intellectual Property Right Department organized seminars, many seminars every year to help teachers and school staff to understand what they should or should not do, and we also provide them with Q&As. The Education Department on its own website also provide explanation regarding the exemptions that are available to schools, and I'm sure that can help allay Ms. Ho's concern. That is the staff. The staff of education establishment would certainly know the extent to which they can make extracts of the copyright works. So I think that there should be sufficient indication will be given to the staff about the scope of exemption. I think you should simply tell the education institutions that so long if it is not for the purpose of trade or business, it should be exempted. But in the ordinary operations of the school, I think you should tell the school, for example, that they should not, for example, use the whole part of the original work, but only a small part. I don't believe that you've thought of this point before I raised it. I think you should conduct more publicity among the schools. And also, the schools are not allowed to display it in public. What about possession? In English, is it translated as in possession of? So during the open day, when the school is recruiting new students, the school may be in possession of such materials. If the school were to in possession of the whole copyright works, or are you providing exemption to only the small extract that is being shown? And the school is considered to be in possession of that small extracts. If the school is in possession of such materials, and if it is used for educational purpose, but every year when they recruit students, the school may use part of it and display it for the students and their parents. So there is a difference here in terms of the extent. Looking at the exemption, the original intent is that for the educational establishments and the pupils, the important want to know whether or not the exemption will cover the major educational purpose, and I believe it's sufficient. Regarding the events which are held once a year and only parts of the original work is being used, then I don't think there will be any infringement of the copyright. Furthermore, this provision has only been expanded. In 2007, we've already introduced this provision, and so far we're not aware of any schools which have encountered difficulties when using that provision. Chairman, I'd just like to make the suggestion. I'd like the Secretary to to put it on record. That is, the administration should follow up on this point. So I want the administration to explain to us in black and white this. That is, if only a small part of the copyright works are being used in the course of organizing the open days or student recruitments, then the schools would not be considered to have infringed the copyright. I think whenever there is an infringement, I think we're talking about, you know, laws being violated. And that reminds me of a very well-known primary school which, you know, had a major incident where someone from outside the school was targeting at a certain teacher, and this teacher is actually an IT expert. He was trying a particular program. He wanted the students to try using the particular program and see whether it works, and he was caught. Subsequently, somebody wrote to the principal, the PTAs, and even the Educational Bureau. That was a few years ago. Nobody knew about, you know, how to handle the situation, and the teacher was simply caught in a nightmare. Because now we are in the course of amending the copyright ordinance, but 4C still says communicated to the public, or so it could be anyone, and you don't have a subject here. You simply say communicated to the public. We don't know who communicated that, so long as the material is being communicated. Well, in that particular case I refer to, it was the parents who raised the issue. I mean, it might not have been out of malicious intent. The parents might thought that the game was very interesting, or the game was very violent. Communication of such a nature, which doesn't have any educational purpose, is problematic. And can you clarify further subsection 4C? Well, regarding 4C, we're already saying that for clause 45, one of the major expansion is that we allow educational authorities and their teaching staff to communicate copyright works, and the recipients would be the pupils. C means that other than the authorized recipients or those who enjoy the exemptions, if they communicate the materials to the public, we are saying that if the communication is by virtue of subsection 1A, what we're saying is that unless the communication is not an infringement of copyright by virtue of subsection 1A. So there is a reasonable defense here. We're saying that this is an exemption. So if you're not given the exemption, you will be infringing the copyright, and the copyright of the owners will be affected. So in the end, we are talking about a question of balance. That is, we want the users to be able to use such materials, and then we will not unreasonably deprive the copyright owners of the rightful interests. So if you are given an exemption, and for qualified persons, they can make such communications and receive such communication, people other than that should be subject to restrictions, and they should follow the existing copyright ordinance. If they make a small copy, a small percentage, it's fine. But if they copy a large part of the copyright works and jeopardize the interests of copyright owners, then it would be an infringement. Chairman, follow up. To put it simply, if the parents were to communicate such works, they could easily be considered to have violated the copyright works. And secondly, you made a qualifying remark. You said if a small parts were involved, it would not regarded as infringement. But that is really problematic. Are you scaring all the parents, especially parents of pupils in kindergartens and primary schools? I think Ms. Mo may note that in providing these exemptions, we have also provided for certain restrictions. That is, education establishments must take all the necessary steps to ensure that the copyright works that they communicate cannot be easily copied by a third party or communicated by a third party.
So with this condition, the educational establishment relying on this section to communicate or further transmit the copyright works, then for parents, it may not be easy for them to further transmit or make copy of the communication. And this is actually a safeguard for both parties. Well, Chairman, coming back to the fundamental question, the schools will be deterred from using copyright works because there is no way to exercise any control over parents, and there is no boundary as far as the internet is concerned. So for safety's sake, the schools may advise all the IT related personnel in school not to use any copyright works at all. This may cause an infringement on freedom, academically speaking. Deputy Secretary. Thank you, Ms. Mo, for your question. Well, let me give you some background information. On 4C, communicated to the public. That is to say, under what circumstances the exemption doesn't apply, and that is 4C. So, as Ms. Zhang said, once the exemption doesn't apply, the original principles applicable to copyright works may apply. That is, whether the amount transmitted or communicated is substantial or not, that is one consideration. And there are also other exemptions under the ordinance which we could consider. For example, whether it is a review or criticism, and whether the exemption under fair treatment could cover that, and this is also another consideration. Well, and also if someone communicates the works, and if exemption doesn't apply, it's actually the responsibility of the educational establishment, not the individual. And we're giving protection for the educational establishment. And as far as the individual is concerned, there is no legal liability. If there is no mens rea, and if the person is not aware of the fact that the work is a copyrighted one, then that is one consideration. And as for other exemptions in the ordinance, well, in fact, as far as those applicable to educational establishments are concerned, it starts from Section 41, and we're now widening the scope to provide more exemption. And we have been working closely with the Education Bureau, and we take the angle of educational work. We seek to help schools to understand copyright matters, what can be used without seeking consent from copyright owners. And once the bill is passed, we're going to tell them that as far as your liability is concerned, you now have to pay attention to the following matters, so on and so forth. But once this bill is passed, before it comes into effect, we'll further communicate with the relevant stakeholders, and the education sector is a very important stakeholder, and we'll continue with this work. Chairman, one final question to clarify another point. In other words, schools will not be responsible for the act of parents, because the schools wouldn't know what the parents would do, and the parents will be personally liable. But as the saying goes, ignorance is no defense. So it doesn't mean that the person being ignorant will be free of any liability. So does it mean that as far as the schools are concerned, if it's a copyright, if this publication is copyright, then we should not even touch it? I recall that when we talked about the copyright of Cantonese films, we also touch upon the same issue, and Ms. Moore also asked the same question. But this is about the education sector. Yes, let me supplement. Well, if it's outside the educational purposes, then we see whether other exemptions would apply, and the parent should be of a similar status as an ordinary user. That is, he or she should know whether he is infringing the copyright or not. So once the ordinance takes effect, we're going to do publicity work so as to let the education sector understand how wide the scope now is, and what consideration will be given, what exemptions will be given. We'll do publicity work. Mr. Raymond Wong. Now about clause 27, which is to amend section 45, reprographic copying made by educational establishments or pupils of passages from published works. Now, of course, we need to keep up with the times. It is it can't work if we use the original heading. We must add other types of work such as sound or film. So as far as the amendment is concerned, I think it's just to update the provision to tie in with the needs. Now, if we look at 195, it says educational establishments specified in the schedule, and also to act for the purpose of the educational establishments. Now, most of the establishments are profit-making, so it is correct that you impose harsh conditions. But what about students? You're actually excluding from some private tuitions. I think we should make it clear here. Maybe that's not the spirit of the law. Deputy Secretary. Now, if it's private tuition, then it will come under another provision. We also give exemption under section 38 for private tuition. So if this is a reasonable request, apart from 38, then 45(1) should also include any copy used in the course of educational purposes by non-profit-making education establishment. I don't know how wide your scope is, but I can't help thinking about 195, the educational establishment. Well, thank you, Mr. Wong, for your question. Now, Mr. Wong has carefully read 195, and that is the educational establishment specified in the schedule. But I think we need to check the education ordinance, whether they're profit-making or non-profit-making. They must be for the purpose of education, not for profit-making. Now, clause 27 adds section 1A, subsection 1A under 45. And I won't repeat it. And this is actually corresponds to section 45 subsection 1, and then the person authorized by an educational establishment such as a teacher or a teaching staff may be given exemption. And then under section 1A B, the establishment takes all reasonable steps. Now, for example, if the notes of a student contains, or notes of a teacher contains copyright work, and on receiving such notes, if the student then exchange notes with others or further transmits it, then what would there be a further provisions on that? Should we give disclaimer or warning on those notes? And would the Education Bureau conduct inspection or investigate into such infringement acts outside schools? Because now in Mongkok there are shops that photocopies teachers' notes, lecture notes. So about the infringement acts conducted by students outside schools, what will you do to deal with that? And I believe that there will be actual implementation, operational problems. Now, actually, when we drafted the provision, we communicated with the relevant stakeholders on what reasonable steps can be taken. Basically, this is about communication through electronic means, and there must be technical measures for them to ensure no infringement via electronic means. So something must be done to ensure that this cannot be copied easily. Why? Because sometimes when you view a web page online, you will not be able to print it, you may not be able to highlight it and then copy and paste it, and there are existing technical measures of this sort that may allow some safeguards. Now, but it's very simple. Just take a picture with your mobile phone. How difficult is it? Just capture the screen with a mobile phone. Of course, the legislation will not be watertight. Well, but it's very simple. You can just take a picture of the lecture notes with your mobile phone. But let's say if you have a pile of lecture notes, it will be really cumbersome to take pictures one by one with your mobile phone. Well, but let me tell you, there are ways to do it. So we're talking about reasonable steps, because my question is this. Don't use such a casual tone. Tell me what reasonable steps you mean. Technology is really advanced. Well, it's not easy to make copies, but I think, although it says all reasonable steps, it sounds objective, but it's actually quite abstract. Now, there are technical measures that can allow viewing, and that can also prevent further transmission or copying or further communication. So, as long as the educational establishments take technical steps or take reasonable steps by implementing these technical measures, they can meet the requirement. But it's clearly stated here that A, the person makes the communication for the educational purposes of the establishment, and also the authorized recipients do not make any copy or further transmission of the communication. So my question is about reasonable steps. Is vague. It's not clear. Technology evolves. The technology may help prevent further transmission, but tomorrow it may lose its effect, because it's about giving exemptions. So please allow Deputy Secretary to explain. Thank you, Mr. Wong, for your reminder. We understand that technology is evolving constantly, and that's why we include in the provision all reasonable steps And this is actually the legal jargon that we use as far as law drafting is concerned. And in previous provisions, we also have a similar wording. We just put down the principle that the establishment should take reasonable steps, and then as a user, as part of the establishment, what reasonable steps can be done as a safeguard. Well, Ms. Zhang mentioned that IT can be deployed to prevent copying, to prevent printing, and you can also set a user account for a user to log in the system before it can be used. These are all reasonable steps. Now, if in the end there are disputes, the court will draw reference from the prevailing circumstances and see if reasonable steps have been taken. So we consider such drafting style reasonable. But like I said just now, when the ordinance comes into effect, we will communicate with the relevant stakeholders, explain to them what should be done, and we would encourage and expect them to follow.
I'd like to go to 27 bracket 6, the new 42 to replace the existing text. Let's take a look at 45 bracket 2. If you read it carefully, of course the punctuation marks will need to be very clear. And after you read it, and if you understand it, I really would commend you for that. Copying or communicating to authorized recipient is not authorized by this section if or to the extent that licenses under licensing schemes are available authorizing the copying or communicating in question, and the person making the copies or communication in question knew or ought to have been aware of that fact. (45 bracket 2), like it's the same as 44 bracket 2. You have not clearly explained what is meant by a licensing scheme. So in other words, the meaning is not very clear, and the Chinese text is also very confusing. For a layman, having read this section of the law, how can you expect him to understand it? Regarding 145 bracket 2, you find subsection 2 and 3 where reference is made to the licensing scheme. So 145 bracket 1 says that in this part the licensing scheme refers to any of the following schemes. 1, the operator of the scheme or someone acting on behalf of the operator, and B, among such cases he would provide special provisions, and whether or not it is regarded as under the scheme. If I read the section, the definition of a licensing scheme, and also 45 bracket 2, so what does it mean? Why is it that the person making the copy or communicating the copy, if you knew that making the copy or communicating it pursuant to a licensing scheme will not authorize him to make the communication? And finally, or to make such communication to the authorized recipient. What does that mean? Permanent Secretary? I think Mr. Wong, if Mr. Wong doesn't understand, many people will not understand. Yeah, I understand, Chairman. If I may explain, we understand that the term licensing scheme has a specific meaning. Normally, the users and people who need to frequently use copyright works will understand the meaning of what is a licensing scheme. At the drafting level, we need to put it in different parts of the bill. Originally, it was in Part 8. When this is about the structure of the text of the bill, So all we can do is to do a lot of publicity among schools. But I think the education establishment should understand the text of the ordinance, because very often they will need to buy copyright works. But we must respect the fact that while education is a good reason for exemption, but then educational purpose can override other purposes. Sometimes copyright works are written or created for educational purposes, and the owner may need to recover the cost or make a profit. So if there's a special arrangement, and if the school were to use the copyright works for educational purpose, there would be a charging table. And if such arrangements are already in place, then the school should not make use of the exemptions to do it. Otherwise, it would be directly infringing the the interests of the creators of the copyright works. Regarding the terminologies of the text, I understand, I can appreciate Mr. Wong's sense of frustration. When I read it myself, I also feel very frustrated. But we've already made an improvement here. If you compare the existing section 42 bracket 2, 45 bracket 2, and the new version, we have already tried our best to make improvements by shortening the sentence, which is originally very long, and we've also used more brackets, commas, and full stops for the convenience of those who read the text. I think the English text is clearer. Even for myself, if I read the Chinese version, I think the sentence is already shortened. We've also made use of brackets, so that whenever possible we'll try to improve on the grammatical structure of the Chinese text. Well, we understand. We're not. But where there could be improvements, we'll make improvements. I'm concerned about the licensing scheme. Since you are providing an exemption here, and you've also provided for, exception here, and people can be caught very easily. So what is the purpose of the amendment? We're talking about education here. I think we should provide for a very lenient exemption. And even if they were to infringe the copyright, I think we should give them the exemption. And that's why you need to explain clearly the part about licensing schemes. It really is a frustrating experience reading this section. Chairman, if you would give me time to also make a comment regarding section 27, 7 and 9. And you're also proposing to add 45 bracket 4 and 5. I will not repeat the whole text here. For 27 and 28, you're proposing that someone engaging in the trade of such copyright works, an active sentence has been changed to a passive sentence. And 27, you propose to delete deal with, to tie in with 27 bracket 9, and to propose new subsection 4. And you're also amending the interpretation, and you've added for any trade, for the purpose of any trade or business, the possession, publicly display or distribute. So the coverage is a lot wider. For the purpose of a trade, I think this expression has appeared many times in the amendment bill. When the administration responded to the question by our legal advisor, when they explained the meaning of deal with, according to any dictionary, deal with means to manage, to discuss, to translate, to deal with as 被用以進行交易, I think is problematic. I hope that For this part, you will move an amendment. Otherwise, I will move one myself. I think we've also discussed this before. Thank you, Mr. Wong, for your reminder. As we said at earlier meetings, we have responded to your legal advisor's queries, and we understand her concern. But the intent here is that to deal with the legal terminology is not new, and it doesn't appear for the first time in this bill. In clauses 41, 44, 45, 72, 40, we also have used similar terms, but we've picked the corresponding term in Chinese, 進行交易. So the terminology has a specific meaning in law, and that's why we are using the same terminology, and the meaning may not be the same as our ordinary interpretation. We understand that we should be very precise. If that is how it is defined in the law, then we should follow that definition. And under the common law system, this is the spirit we should follow. If you look at the existing ordinance and the structure of this provision and the terminologies used, we're still using the word deal with. I will not repeat the detailed explanation here. On January 15, 2015, we've already replied to the question by your legal advisor, Mr. Yu Siwing. I also have a question regarding bracket for A, B, and C. B is very clear, sold or let for hire or for exposure sale or hire. C, communicated to the public. I think the scope is much wider here. If you communicate to the public, the question is whether or not the person making the communication has a deliberate intention. The Permanent Secretary said that the extent of the communication is a determining factor to determine whether the person will be prosecuted. But for the judge or the person who decides to make the prosecution, it's up to him to determine whether or not a lot or not a lot has been copied. So I think you should set some preconditions here. For someone to deliberately make a communicate to the public, or the person making the communication is not aware. Otherwise, many people may fall into this trap. So could we further elaborate here and say that you only be in breach of the law if you were if it's not done by yourself? As we explained earlier, this exemption is originally meant for the educational establishments, which may need to communicate the material to the public, and the recipient are the students. For 4A, other than purposes of subsection 3, communicating these materials electronically would be an infringement. The reason, why is it that we don't need to mention whether the person has an intent or deliberately, infringing the copyrights? Well, under the copyright ordinance, if you've done something, you have infringed copyright, and if you deliberately infringe the ordinance, then it's a more serious offense. But for C says whether you're aware or not, so long as the exemption is given to the authorized persons to make the communication, and any person other than the authorized person are not allowed to engage in such acts. These are restricted acts, and therefore we do not need to further explain here. We're saying that the exemption only applies to authorized persons. If you're not an educational establishment, you shouldn't communicate the materials in this manner. So the scope is really very wide. The educational establishments may distribute such materials to pupils and parents, and once the latter obtain such materials, we don't know to whom the materials will go to. It could go to the private tutor or someone else. So, then someone may therefore, breach the law without knowing that they have done that. So I think the scope here is too wide. And you said that if the person only use a limited part of the copyright works, it's not a problem. But there is no objective definition here. Different people may have different interpretation of what is meant by using a large part of the copyright works. Without these two preconditions, then the judge can easily find anyone to have breached this ordinance. Mr. Yiu is looking at it from the perspective of the parents. First of all, we're looking at the question of the mens rea. And I think we shouldn't worry too much about criminal liability, because in the case of criminal prosecution, we have to prove that there's a mens rea. And secondly, the extent of the materials being used. Again, whether or not a substantively large part of the work is being used, I think there are principles governing and case laws to determine under what circumstances a copyright has been infringed.
So any user should pay attention to these principles. Of course, we will, as I said just now, do publicity. Mr. Ray Chan. Thank you, Chairman. I'd like to talk about all reasonable steps as well. In previous sections, I asked the same question. Now, would a disclaimer or a warning paragraph be regarded as all reasonable steps? And the answer is no. There must be all reasonable steps. That is, the party should exercise due diligence. That is, for example, to prevent printing, to prevent right-click saving, and exemption would only be given after taking all these reasonable steps. But like Mr. Raymond Wong said, you could capture the screen and then print them out. So it's not really very advanced technology. But Mr. Chan, actually, I tried but failed. What I mean is, as I said to Mr. Wong just now, we're talking about reasonable steps, all reasonable steps. So the focus is reasonable. So I thought that I already prevented saving, right-click saving, and I thought that I'd taken all reasonable steps, but no, I also need to prevent screen capping as well. So I think the responsibility is with the user. So if I can't prevent users from capturing the screen, I won't be regarded as having taken all reasonable steps. I don't think this is reasonable, but I'd like to reiterate my point. And point number 2. The sense of failure. Well, I think just by lengthening the subsection would only increase the sense of failure. If you ask whether it's easier to understand the new subsection 2 or the old subsection 2, I can't tell. Now, new or ought to have been aware of that fact, I'd like to ask about this. You don't need to include this because it is presumed that the person knows. Well, I think this is just a matter of translation because the English version also has the same bit. Deputy Secretary. Now, all reasonable steps, I explained just now that the steps should be reasonable. That's important, and that's not a new legal concept. And in the previous versions, we also have the similar terminology. Any example? Well, throughout the years, we have not received any feedback or response or complaints under the ordinance that such a terminology is unreasonable, and that this is impossible. Of course, after the bill is passed, we will also do publicity and explain what is meant by all reasonable steps. About the use of punctuation marks in subsection 2, whether it will be harder for a reader to understand in the longer subsection 2. Well, because the this is true that because the new subsection 2 encompasses more legal elements, has a wider connotation, and the paragraphs has become longer. Now, the original is copying is not authorized by this section, if so on and so forth, but this is not readily accessible by users, so we've changed it. In the Chinese version, we start by saying if, and then we talk about the conditions, and then we talk about the consequence, then, in the Chinese version. And that's the spirit of the provision. That means we talk about the circumstances under which the exemption will not apply, and the way of drafting is just for a reader to understand it better. Of course, mostly it would be judges and lawyers and legally trained personnel who read the provision, but we should allow ordinary users to easily understand the provision as well. So, in short, a user has the responsibility. So, as long as the establishment takes all reasonable steps, the person cannot rely on the fact that the person is ignorant of the fact. Well, we basically follow the principle. If under objective circumstances you did not know and ought not to have been aware of the fact, then you would not be subject to the limits of exemption. That is to say, your liability would somewhat be lessened. Ms. Sit-Ho. Thank you, Chairman. Now, I'd like to talk about the Chinese version. Now, I think one would have a sense of failure if one doesn't understand the English version, despite the high level of English proficiency. But likewise, with the Chinese version, I don't know whether you'd like to give the public an impression that you are being modest, or whether you're arrogant or you are modest. Well, but let's not argue here. I didn't mean to offend any member. Well, I meant to say frustrated. Well, I was actually working on the bilingual version of some legal text, and I was trying to find out the translation for the word frustration. Well, let's not argue over this word here. I think the context of these two words are different. I think it's not about the bill, but since... But anyway, let's talk about 44 subsection 4 or 45 subsection 4. Both provisions seek to replace the original subsection 3 paragraph 2. Dealt with, or in Chinese 進行交易, carries a very narrow scope. That means sold or let for hire or offered or exposed for sale or hire. So very clearly, when it comes to sale or hire, money is involved. But in the two subsection 4, you have widened the scope of dealing. So when you widen the scope of dealing, or the term dealt with, the scope for educational purpose is narrower. When it comes to admission, students' admission, then the education establishment may fall into the trap. And you preserve the sold or let for hire bit, and then you have also included new elements possessed, exhibited in public, etc. And then in the 1A you talked about in clause 27 about amending section 45(1)(a). It says takes all reasonable steps, but if it's for profit making, if it's part of a business dealing, then it's already covered by subsection 4. Then, like we said just now, sometimes for an establishment, for an open day, money may be involved. So subsection 4A should be deleted. Subsection 4B and C should suffice. I don't know why you have to include 4A as well, but the content is different. Distributed, possession, that's different from the points B and C. Now please let the administration explain. Chairman, you're correct, because for the new subsection 4A, first of all, it's otherwise than for the educational purposes of the educational establishment concerned, for the purpose of, or in the course of any trade of business, possessed, exhibited in public, or distributed. And Ms. Ho just now mentioned that in fact B and C already covered profit-making activities such as selling or let or hire. But we don't just want to cover that. In fact, in the course of any trade of business, the exemption should not be granted, because if it is otherwise than for the educational purpose of the educational establishment concerned, then if the the copy is possessed in the course of any trade of business, it should not come under the exemption. And then we consider that it is not in line with the legislative intent if the copy is possessed, exhibited in public, or distributed for the purpose of or in the course of any trade of business. And if it's possessed, exhibited, distributed otherwise than for the educational purpose, and instead is for the purpose of or in the course of any trade or business, then it should not be given any exemption. This is to clarify the legislative intent to it and to strike a balance. Chairman, then I cannot agree. Now, about distribution, I think this can also come under communicated to the public under C, but this is different, because communicating to the public, it means via electronic means. Distribution means distributing hard copies. Maybe the starting point is the same, but what I find puzzling is exhibiting in public. This can be for something other than profit making, such as during an open day. You can't call this an activity for the educational purpose, but no money is involved and the copy is not distributed or exhibited in public. Thank you, Chairman. Thank you, Ms. Ho, for the follow-up question. Now, let's come back to the basic principle. The spirit under the copyright ordinance is to protect the private ownership of the copyright owner. And if the activity involves making of a profit, then the activity would be caught under the ordinance. But even if the activity is not for making profit, then if the copyright is infringed, then there should be the corresponding liability involved, and that is why we have the provision. And actually, there are similar provisions preceding that as well, but when it comes to the extent of legal liability, well, under the civil justice system, of course, first of all, we need to establish that this is a civil wrong, this is a legal wrong, and that the owner must suffer a loss, an actual loss, before litigation can be ensued. And we just follow the same principle. I think the provision is very clear. For the purposes of selling or letting for hire. It's not the same as just exhibiting or distributing something in public in an ordinary manner. No, Chairman, it doesn't say that. No, it does. 4B. 4B doesn't say exhibited in public. Exposed for sale or hire. But my question is this. This is offered or exposed for sale or hire. So if it's not exposed for sale or hire, then it doesn't come under this. Then it comes under 4A, Chairman. 4A is about exhibiting in public. Now 4A is very clear. Otherwise, then, for the educational purposes of the establishment concerned. So if it's for educational purposes, then it won't come under this subsection. So, Chairman, that's why I gave a very clear example. Student admission, that's not for educational purposes, and I believe the Education Bureau share the same understanding, and it can be regarded as part of the business of the educational establishment, and yet this is not about making profit. Now, I understand Mr. Wong's point. Now, we agree. I think we have agreed before as far as civil liability is concerned. But I'd like to know whether 4A means criminal or civil liability.
If you display the materials on the day of student recruitment, it should be a case of civil liability. I think if you said that we've already agreed with some earlier ordinances, but if 4A falls under a it's about a criminal liability, it's really problematic. 4A basically is about civil liability. The threshold for proving criminal liability is different. The main intention here for 4A is that Section 45, it's meant for to cater to the educational purposes of the educational establishment. And 4A clarifies that we don't want people to abuse the exemption. That is, if you're not doing it for an educational purpose, if you're doing it for a trade or business purpose, then you should not be entitled to the exemption. Of course, they would not be. Of course, the person may not be in breach of the law, the other section of the law. But here we want to clarify the extent of the exemption and who are the authorized persons who are entitled to the exemption. I'd like the legal advisor to help us make a search. That is, are there other provisions which says that when we breach 45 subsection 4B, what would be the penalty? Well, I've not been able to find that myself. Perhaps our legal advisor or the officials can help us do that. Mr. Christopher Chung. I think the provision is very clear. Regarding the point made by Ms. Ho, that is open day or student enrollment, I think the eventual purpose is still an educational purpose. And therefore, I don't think that would be a breach. I think for student enrollment, basically, it's still for an educational purpose, because this is an educational establishment. On the other hand, I think the word display or exhibit, does it mean the playing of video or audio recordings? Would that also fall under the definition of exhibit? If sound records or videos are being played, well, why don't you include that as well here? Well, communicate to the public. I think for some educational establishments, we're saying that if we're talking about an educational establishment and the teachers are broadcasting certain sound or video recording, we will give them an exemption. And we say this does not constitute a public broadcast or performance. So all the exemptions for educational institutions and all those provisions have a different intention. and the coverage are different. So we need to look at different provisions, and if you do that, you'll know that the copyright works which are being quoted, we give them exemptions. And according to Section 40, if 45 is clause 45 is silent, then probably it's covered by other sections of the ordinance. You say there are other provisions. Well, that's. I think Section 45 is basically for the educational institutions. Why is it that in C you say communicate to the public, but not in the case of A? The main reason is that A, B, C cover different things. C is targeting against communication to the public. Right. If there are no other questions, I think we can move on. I hope that we can expedite our process a little bit. I know. Let me finish first. What follows are only technical amendments. I think we spent more than an hour on this particular section, and I believe that there are many matters of principle which have already been resolved. Well, the authorized recipient, Mr. Sin Chung Kai asked a question. That is whether students would also be included, or rather the parents of the pupils. Especially for kindergartens and primary schools, the parents may be doing the homework together with the pupils, and they would also have access to the materials. So it's being communicated, but the parents is not an authorized recipient. Thank you. It's all about the educational purpose. If the pupil is using such materials to learn, then the exemption would apply. What about a parent doing the homework together with the child? I think you've interrupted the Permanent Secretary halfway through his reply. Sorry. I think we can go back to Section 44 at an earlier meeting. Oh, sorry, it should be 43. And we say that for educational establishments, if these materials are being broadcast, if the audience only includes the teachers and the pupils or the parents of such pupils, I think it's the same legislative intent here. That is, if it is for educational purpose, for a pupil who is a minor, then the guardian can represent the minor to exercise certain of his legal rights. Although we don't mention parents or guardians here, but they are already covered. If the purpose is that the parents are acting on behalf of the pupils to receive or to view such materials, then they are already covered. So it's the same as in Section 44. I'd like to point out to members about subsection 2. To put it simply, if the persons in question knew or ought to have known of that fact, then basically 1 and 1A, the exemptions under 1 and 1A would not apply. If members read the Chinese version of the text, knew or ought to have known, I think the only difference is that in the latter part we have the Chinese words 應該 or should, but the English text is knew or ought to have been aware of. Knew and aware imply a different degree of knowing or knowledge. In Chinese is 已知道 or 應已知道. So the Chinese version cannot express the difference between knew and aware. So I'd like to know what is the legislative intent there. So is there any difference in the connotation for new and aware? So is the Chinese version or the English version more compatible with the original intent of this particular section? Perhaps I can ask our law draftsman to respond to that. In the English version, we use the term new and ought to have been aware. I think there are other parts in the copyright ordinance which also use the same terms. Why is it sometimes we use the word new, sometimes we use ought to have been aware? We are basically following the Copyright Act of the UK. We do that because during the localization or adaptation of the Copyright Ordinance, the Law Reform Commission recommended we follow the English text, the English Act. That's why we've used the word new and ought to have been aware. In the Copyright Ordinance, no court has provided an explanation of the meaning. But in the Canadian courts, new and ought to have been aware is regarded to have the same meaning. Our legal advisor already pointed out that in Chinese it's 已知道 or 应已知道. Or could it be the case that the Chinese translation is not 100% accurate? Well, in the bill we have used the same terms in other parts of the ordinance. First of all, there's no major difference as far as the legal concepts to which the two terms apply. It's just if these are the words used in the English version, perhaps in the Chinese version, we should adopt a more concise style. If the expression already fully reflects the legislative intent, then it would have already reflected the intention of our policy. The original meaning of new and ought to have been aware. If they are interpreted to mean the same thing, why don't you simply say in the English version ought to know? There must have been some different meaning. New means you already know. If I'm aware of you, then I may only have a very vague awareness of that you exist. So the meaning is not the same. Why is it you cannot have the exact meaning translated into Chinese? It's only in the copyright ordinance that they use the terms new or ought to have been aware, but it's not being used in other legislation. We've not changed the terminology here. We've only put communication under subsection 2, but we've not changed new or ought to have been aware. Is it possible that you can also amend this part as well? Could you move an amendment? Well, it's not just here that they've copied the English Copyright Act. They've also copied the English Copyright Act elsewhere in this ordinance. The important thing is that we know what is happening here. In the English version, could you follow the English Act? According to the Bilingual Law Commission website, I think new or ought to have been aware has been used 392 times. So in Chinese, can you say in the Chinese version that there is a difference in degree, or we can use new or ought to have known? That again has been used 392 times in other ordinances. Mr. Lam. I think the consideration here, this is the drafting point. That is what principles should be followed when drafting the law. And if, of course, it would be best if we could be consistent. Another principle is the certainty of the law. Since 1997, when the copyright law ordinance commences, we've seen the law drafted in this manner, and we've not seen any major difficulties when the laws are being applied. So from the legal certainty point of view, I think following the style of the existing provision is more appropriate. So long as we can bring out the legal concept here. What about the Chinese translation? In other parts, in other ordinances where new and ought to have been aware of, are they also translated as 知道 and 英语知道? Talking about bilingual legislation, and both versions having the same legal effect, I think we are actually, a pioneer, legal advisor. Having heard members, I think for subsection 5, the definition of authorized recipient, the present draft indeed may not cover certain scenarios. For example, you may have a sibling, a brother and sister attending the same grade in different schools. Can they share each other's homeworks and so on? I think that is a very common practice in many families. But apparently the present draft does not cater to that scenario. And the other situation is in regard of private tutors. We're not just talking about the teachers and teaching staff of the education establishment, but also the parents.
Thank you, Chairman. Well, let me explain once again that the exemption under this provision is about special circumstances, and then in the course of teaching and learning, when the personnel involved, that is a teacher, and in fact the term teacher is just a term. That means the person engaged in teaching, and also the pupil will be given exemption. And if someone undertakes private tutorship, this is in fact outside the scope of this provision. We can then deal with the issue by way of other provisions, whether it's private tutorship, whether fair treatment should apply, and we have over 60 clauses, and we have different exemptions to deal with different situations. And let me supplement. At the last meeting, we also covered exemption under different educational activities, and section 41 actually refer to fair treatment for educational purposes by educational establishment. It covers a very wide scope: fair dealing for purposes of giving or receiving instruction, and the intent is somewhat different from this one. So for the existing copyright ordinance, if it's for private tutorship, then it should come under 38, whereas for sharing of teaching materials between siblings studying in different schools, in fact the exemption under section 41A covers a very wide scope, and such a situation is covered. So may I rest assured the legal advisor that we have different exemptions under different circumstances for the purpose of using copyright materials for educational purposes and for giving or receiving instruction. Well, I understand that, but I need to clarify the issue. Before legal advisor raised this point, Ms. Zhang said that rest assured, if you look at section 43, parents are covered. Now, after our legal advisor has raised the issue, now the two of you once again mentioned 41A and said we should refer to 41A instead. So which section should we refer to? You just cited a different section in your answer. So we're worried. Is it because you haven't really thought it through? Please go back, think it through, and give us a written answer. And let's not be this vague. I think she is responding to your question on whether it should be covered under Section 41A. Now, please tell us which section we can rely on. Please allay our concern. And legal advisor mentioned sharing of notes between siblings. They may not be studying in the same grade or form. Sometimes maybe they just let the same private tutor read the notes. I really want to make things clear. Would the administration please go back, prepare a paper to reply to all the concerns raised over the past 2 hours, so that we have something written, so that we know very clearly what we're talking about. Thank you, Ms. Ho, for your comment. Now, we try to answer some follow-up questions just now, and we cited some sections in response to the scenarios raised in the questions. Of course, we can rely on different sections in different scenarios, but of course we can explain to members the scenarios raised just now to allay members' concerns, because under the copyright ordinance, we have different exemptions for different circumstances, and we're happy to give paper. Yes, Chairman, please urge them to give us a paper as soon as possible. Ms. Chen Yunhan. Now, I'm very unhappy with this arrangement, because at this meeting, I happen to be chairing another meeting in the next room, and the last time it was the same. Now, this is an important bill. Of course, the meetings may clash, but I hope it won't happen every time, because it's a loss on my part since I have to chair another meeting. I know the Secretariat is already making very hard effort. Well, yes, we try to accommodate everyone. So next time when we look for an available slot, we'll try to accommodate you as much as possible. I'm sorry, Chairman. It's really impossible to accommodate everyone. Ms. Ho, you're right. You're also chair of a meeting. Now, we already scheduled this meeting in advance, so unless we have extra meetings, I'm sorry, but we really need to discuss the issue of retirement protection in the subcommittee next door. Now, I want to go back to 39 in a moment. Right, if you can't ask your question at the meeting, after the meeting you can ask them directly. All right, members. It's now 12:23. If there are no other follow-up questions on this clause, so maybe we'll wrap up here. If you have follow-up questions, please ask them directly. Oh no, please ask now. My follow-up is this. We urge the administration to give us paper as soon as possible. Yes, they'll do that. What about the point about private contract I asked last time? I am waiting for your paper. Yes, we're working on it. We're working on it carefully. All right, the next meeting is scheduled for the 17th of March, 4:30 p.m. Meeting's adjourned.